case on this morning's docket. That is case number 114567, State of Kansas v. Grant Wilson.
If it please the court, this is a case on the state's petition for review. I'm asking this court to review the Court of Appeals ruling that I committed planned, prejudicial, reversible misconduct at a hearing.
Excuse me, counsel. Before you proceed with the argument, for our camera and the folks watching from home, could you once again announce who you are and who you represent?
I'm sorry. Keith Schroeder, Reno County District Attorney on behalf of the petitioner.
Thank you.
What the Court of Appeals found involved a hearing outside, a non-jury hearing, on a motion to correct an illegal sentence. I guess going back to the facts of the case, this involved a 13-year-old girl who slipped out of her home without her parents' knowledge, went to a party, and ended up having sexual relations with a young man who just turned 18 years of age. He was arrested for rape and for aggravated criminal sodomy under Jessica's law that carries a life prison sentence.
He was arrested on those charges, but that arrest probable cause affidavit is not what initiates criminal proceedings, is it?
It is not.
It's a charging document that your office prepares.
That's correct.
And what did the charging document charge this individual with?
I only charged with aggravated indecent solicitation of a child, level 5 felony, and agreed to the guideline sentence, which would be community correction supervision. Now, before I charged him, he had a first appearance on the charges of rape and aggravated criminal sodomy. The judge at that time reviewed the affidavit of the officer and found probable cause. That's in the appellate record. I charged the aggravated indecent solicitation of a child. He received probation. Didn't do well on probation. He didn't follow his sex offender itinerary. He didn't go to sex offender counseling. He continued to have contact with underage girls. We filed the motion to revoke his community corrections. It was revoked. He was sent to Labette Correctional Conservation Camp at the time, where I think he failed, and ultimately had his sentence executed. It was later, it's kind of a perfect storm case, and I apologize for my part involved in it, but it starts off with the fact that we had hundreds of cases around the state of Kansas where persons were convicted of this crime, and everybody missed the fact that the law called for lifetime post-release supervision. You've seen many of those cases before you. And so in this particular case, it was missed by the court service officer who prepared the pre-sentence investigation report. That's in the appellate record. It was missed by the judge. It was missed by myself. It was missed, we assume, by the defense counsel. And when we found this out, as many other cases, we filed a pretty standard motion to correct a legal sentence. Now, that was filed by one of my deputies, Steve Maxwell. I had assigned him to handle these type of cases. When it was called at the docket, it was called in a sort of a cattle call docket hearing. And for whatever reason, Mr. Maxwell wasn't present, and so I stepped in to handle the case. And so that's kind of where we get to where we're at. The defendant argued a unpublished decision, State versus Proctor, claiming that it was unconstitutional under the facts of his case for him to be given lifetime post-release supervision. And also at the time of that hearing, there was a statement in the appellate record, volume 9, page 4, by counsel before I ever spoke. And counsel says, I understand that the victim in this case was 13 years old. She and another friend had snuck out of the house that evening and joined some high school students. Apparently her parents didn't realize she was gone. And granted, Mr. Wilson did make a terrible mistake in engaging in sexual conduct with this 13-year-old. However, he described to me earlier that he's making no excuses for what happened. He takes full responsibility, but says, given his young age, he just didn't really have the ability to make a good decision at the time. Now that he's mature, looking back at it, he knows what he did was wrong. It was after that statement that I then make the comments to the court about this involved the digital rape and sodomization of a 13-year-old girl. And I point that as legally that involves a crime of sexual violence. Either under the Sexual Violent Predator Act, under the Kansas Sex Offender.
So you've committed a sexually violent crime if the police arrest you for that crime?
Well, I'm saying those acts constitute that, not with the charge. That's not what I charged him with. I obviously gave him a break.
But at that point, there had been no proof of those charges, no plea of guilty to those charges. So there was an allegation of those charges.
There's an allegation, but the statements by counsel pretty much constitute somewhat of an admission that was uncontested.
There's no admission of digital rape.
No.
I mean, that's completely outside the evidentiary record.
Well, that was the charge of the rape. But
It's outside the evidentiary record, and you're not allowed to go outside of the evidentiary record.
This is something that Justice Boozer raised in his dissenting opinion, and that is, he questioned at what point there had to be, the evidentiary record had to be there for a sentencing or some type of a pretrial hearing. Frequently, counsel show up and proffer evidence and proffer statements of the facts that happened in the case. This is how we got where we are. He admitted at the time of his plea, and that's in the majority decision in this case. He admitted at the time of his plea that he'd had sexual contact with a 13-year-old.
But not digital rape.
I can't find anything in the record about digital rape.
I mean, it isn't even...
Unless that's in the language of the complaint. Well, I'm sorry, it wouldn't be in the language of the complaint because I only charged aggravated indecent solicitation, so right. I withdraw that.
And I think the factual basis for the plea was simply that there were sexual relations.
Yes. Because we were just trying to establish a factual basis to support aggravated indecent solicitation of a child.
I want to back up a second and figure out the scope, the universe of issues that are here on review. And frankly, I struggled with your petition for review, trying to figure out exactly what you were challenging as error by the Court of Appeals. So let me just ask. On the preservation question, you had, in the Court of Appeals, you had argued that there was no objection to your comments,
yes,
and so that the question wasn't preserved. Court of Appeals said they were going to go ahead and decide the question. Did you claim in your petition, do you think you claimed in your petition for review that the Court of Appeals erred in rejecting your preservation argument?
I didn't really address that.
Okay, so
reason,
that's settled. So the objection question isn't up here.
There are many reasons why I think this case should be here.
That's not my question.
Yes.
I got a specific question in front of you, which is the objection. Is that issue in front of us based on your petition for review?
I don't believe so.
Okay.
I think the sole issue that I'm raising is a finding that I committed planned, prejudicial, and reversible misconduct.
Well, misconduct's got two parts to it. The first one is whether you were outside the wide latitude,
Yes.
which is just whether you made a misstatement. Do you contend that the Court of Appeals erred in finding that you made misstatements about the digital rape?
They found that I made misstatements about...
Were they mistaken when they found that? All I want to know is where you think the Court of Appeals erred. And I'm trying to drill down into the details. And the first one is whether you misspoke at all. And are you claiming in front of us that the that the Court of Appeals erred in finding that you misstated the facts of the case?
In general, I am. Because my interpretation of the majority opinion of the Kansas Court of Appeals was that I went outside the record when I described sexual acts that occurred with a 13-year-old girl. Now, if you're talking about just digital rape or the digital penetration, I'm not sure. I may have gone outside the scope of the record on that and just gone based on my knowledge of the case. I acknowledge that, but my understanding is they found that I had gone outside the scope of the case or the evidence of the case, and it wasn't supported by the case, that there had been some type of sexual crime committed on this 13-year-old girl. That was my take on it. Was they were saying that's how I misled them, and since there was no record of it, they coupled that along with my misquoting the facts of the unpublished decision.
Well, you admit that. I mean, you fell on your sword pretty quick in the Court of Appeals on that one. Let me ask you one other question. In your petition for review, you did not cite State versus Sherman, which is the case that we kind of cleaned up or modified our what used to be called prosecutorial misconduct and changed the name to the terminology to prosecutorial error, and then changed the second step in the two-step analysis. You didn't cite Sherman. Is it your contention, and we asked you guys to be prepared when you came here today to tell us what test to use, do you think Sherman applies to a claim of prosecutorial error / misconduct that occurs in a non-jury proceeding like this?
I think it could be modified to do that.
How would you modify Sherman?
Well, I think that the question isn't going to be whether the impact had an error on the verdict, but whether the error had some type of impact on the court.
Well, I think you can change that to outcome.
Yeah.
And in
The
fact, some of the
outcome-
language, excuse me, counsel, some of the language in Sherman talks about verdict, some of it talks about outcome. So I think we can agree it's outcome.
I've handled other cases that come out of the court that say we really don't have a standard of review on this issue. And even Justice Boozer, in the dissenting opinion kind of comments, he refers to 3 different jurisdictions that do have set forth rules. One is in Wyoming. They use a plain error standard, and in a similar situation involving misstatement of fact in a non-jury setting. And they describe 3 parts to that. The record is clear about the incident alleged as error. There was a transgression of a clear and unequivocal rule of law, and the party claiming the error was denied a substantial right resulting in material prejudice. He cites a Connecticut case, State versus Tirieni or something like that, Justice Boozer, 44 Connecticut App 232. In Connecticut, they apply a 2-pronged inquiry. Did the information at issue contain some minimal indicia of reliability? And if it did not, did the trial court substantially rely on the improper information in fashioning its ultimate sentence? And then he relies upon an unpublished decision out of New Mexico. And in that unpublished decision that he's referring to, New Mexico essentially requires the defendant to show some type of prejudice, that the court relied upon the statement. So in this situation, I misquoted the facts of Proctor, because I thought it was a ag indecent solicitation type case with an undercover police officer, when in fact it did involve another child, an actual child. In that situation, they required the defendant to establish prejudice, to prove that he was prejudiced in some manner. And that was one of the issues that was raised by Boozer in the dissenting opinion, is that he could find nothing in the record that indicates Judge McCarville ever relied upon any of those statements. I mean, the bottom line is I've been doing this for 30 years. This is a serious allegation. I mean, if you find that I intentionally misled the court and did it premeditated, the only thing I see that the appellate court says proves it is the fact that apparently we argued this case within 30 days of the time the motion was filed. I didn't even file the motion. And Boozer addresses that.
What
Can
do you? No, go ahead, Chief.
Well, Since we have Topeka West here today,
No, you don't need them.
Go ahead,
Thank you for
Justice
the deference. See what you get as a graduate of Topeka West. Now you made me lose track. No, what do you believe is the scope of what you can argue in a scenario like this? You have a probation revocation, you have a constitutional question. Are there any limitations as to what was charged, what were the facts leading up to the charges, what was ultimately pled to? I mean, I think you're arguing that you basically have carte blanche when it comes to whatever facts there are in this case, whether they're proven or not proven. Where do you stand with that? I mean, you said you've been doing this for 30 years. Is that what you think that you can?
Well, obviously, being truthful is important. Being truthful about those facts. But yes, I do think there are some times that there are facts outside the scope of the issue that's being presented to the court that are important for the court to understand. Perhaps a prior conviction. Perhaps.
Well, no, in this case, what we have is we have you charged a crime, and the defendant answered to the crime in the charging document.
Yes.
Now and he was sentenced for that. Now on resentencing or a motion for resentencing, you want to argue acts that were alleged that defendant has never had an opportunity to refute. Why isn't that a due process? If you charge him with one crime and he answers to that crime, and then you go back later and you want the judge to sentence based on acts that you think he may have committed that were really a more serious crime, that defendant's never had an opportunity to answer those allegations. And so why is that fair game?
I think under the facts, the totality of the facts of this case, I mean, you have to look at the overall. He was arrested and charged with something that could carry a life in prison sentence. There was a plea negotiation, a charge that was reduced, a plea.
Well, I understood this wasn't amended.
No.
This was the initial.
Yes, there had been negotiations before I ever filed the charges with Mr. Holnick. So this was a decision. I can charge this or I can charge that. And so I can charge this. At the time of the plea, he acknowledged sexual relations with a child that was under 13 or 13 years of age. That was acknowledged by counsel at the time of the hearing on the motion. Those are clearly facts outside this. They were trying to argue that there was mitigation that would support Proctor and the court imposing something less than lifetime's supervision. They were arguing the mitigation. I was countering with the aggravation. And I wasn't the first one that raised this. They had raised it as well. So I raised the fact this is what the cases are really about. This is what he pled to. So to say that there's some mitigation in the facts of this case, we believe that there are not.
I don't understand, counsel. How is it fair for you to claim that this defendant committed digital rape when there's nothing in the record at all? Even if, I mean, supported or unsupported, nothing in the record that supports that. How is that fair? And due process is about fairness.
Well, I guess the way I respond to that is, again, taking into consideration the fact I'm in a courtroom, they call a case, I say, I can handle that. It was originally my case, I'll go up and handle it. Having had time now to go back through all of the record and what's in the appellate file, I can say I don't think there's anything in there that says anything about digital penetration. Okay. But at the time I'm standing up before the court, at that moment, without the benefit of hindsight, looking back at everything that's in the record, I'm going based on my memory of the facts of this case.
But counsel, that you've just recited something that, which, if true, is an innocent, arguably innocent explanation for why you said what you said. That does not answer Justice Biles' question. I mean, in Sherman, we made it very clear that there's a difference between what's fair and the level of culpability that might attach to a prosecutor's actions. I mean, so you could make an innocent mistake. Sherman says this clearly. You can make an innocent, quote unquote, mistake that still violates due process, that still creates an unfair circumstance. I think that's the question, and you're not answering it. Again, so how is it fair for you to, even innocently, represent facts that aren't supported in the record?
Well, again, you're saying sidestacking when I say I didn't realize that that wasn't in the record. But I guess it's difficult in any of these cases to come in and argue about what the plea negotiations were in the case and what benefit was given to a defendant and showing that without referring to other facts that maybe aren't in evidence. You're saying we could have done this, we could have done that, but we didn't. And you can't make those arguments in front of a court in any situation. Once a prosecutor shows some mercy or does this, later if the prosecutor needs to say, I could have done this, but I didn't.
Counsel, let me see if I can cut through this. According to my notes, you have just admitted that innocently you made a mistake when you told the court that he had committed digital rape.
I don't recall.
Are we clear on that?
I think we are.
All right.
I assume that there was something there. I don't recall anything specific.
And then the second thing in my notes is that you agreed before you came here today that you had misstated the holding and facts of Proctor.
Yeah, I did that.
Okay.
I obviously.
Assuming those still to be true, your admissions today, what do we do with that in terms of the relief that's sought by the defendant? What is our standard for determining what, if anything, we do? You started reciting cases that Judge Boozer had listed in his dissent, but distill that or synthesize that for me and say, what standard are you asking us to apply here in light of these two concessions?
I think there has to be some measure, there has to be some standard that requires a showing of prejudice. Was there prejudice that occurred to the defendant in this case? There's nothing in the appellate record that shows that there was prejudice. Judge McCarville was familiar with this case. He handled the first appearance. He handled the plea. He handled the probation violations. He made references to the fact he was familiar with the facts of the case. He had made those decisions. There was the provision where I misstate the facts of Proctor was a very small part of that hearing. I guess we talk about the digital rape thing. What I was focusing on was rape. I mean, my contention is that they conceded rape.
When
I understand
you
your
said at the plea hearing that he had sex with her.
Yes.
Yeah.
Yes, and so that's the digital penetration is a form of rape. So I was focused on the rape. And that's when I came here today. That's why I kept saying, well, generally what I was looking at was the crime of rape and aggravated criminal sodomy. Now you're focusing in on the detail of the digital rape. I don't remember there being anything in the record about it being with the finger.
Justice Biles was asking you questions a few minutes ago about the same question I asked you a minute ago, and that is, what standard or test do we apply to gauge your conduct here? He was leading the conversation, I think, by asking whether our test in Sherman applied here. And I'm not sure, at least according to my notes, we ever got a clear answer, because you started, I think, going into the cases that Judge Boozer cited from Wyoming, Connecticut, et cetera. So do you agree or disagree that Sherman's test applies here?
I believe some of Sherman applies when we're dealing with plain error or a prosecutorial error instead of prosecutorial misconduct, where you misstate something as opposed to deliberately doing something, deliberate misconduct. But I think you have to have more of a plain error standard with some showing of prejudice to the defendant when you're outside the scope of a jury.
Well, let me recite, I think maybe Justice Biles already did, the test from Sherman and tell us whether you agree or disagree. And I'm going to modify one word because it talks about a verdict.
Right.
I'm just going to change it to a decision.
Right.
Okay. Whether the error affected the outcome of the trial in light of the entire record, i.e., where there is no reasonable possibility that the error contributed to the decision. So is it your position that based on these facts, there is no reasonable possibility that your misstatements contributed to Judge McCarville's decision?
Yes.
All right. Thank you.
And I think
And-
that's what
and-
Judge Boozer determined in his decision as well. I guess my concern, as I started to say earlier, is this is a serious allegation of intentionally misleading or
Well,
or making
we
statements.
understand that, Counselor, but you're out of time. I want to try to dig down into what we were really talking about were the Freeman factors, and there are three factors, and the first one deals with the facts surrounding this particular defendant.
Yes.
And I don't understand how that you could say there's no reasonable possibility that it would have affected the determination on whether lifetime post-release was appropriate for this person doing what they did when you're alleging facts that were at best simply allegations, and more detailed than the allegations, and defendant didn't get an opportunity to deal with that, and how, I mean, if nothing else, Judge McCarville didn't have both sides of the story to make a determination on the first Freeman factor.
Well,
And the Court of Appeals says, let's send it back and have do-overs and have an evidentiary hearing on the Freeman factors. And so why isn't that what needs to happen here?
I disagree about Judge McCarville not having that information. He did. He had found probable cause at the time of the arrest based on an affidavit.
He had the police officer's allegations.
Yes.
He didn't have the defense side of the story, did he?
No, but he's trying this case. Or if you call him, he's not just a trier of fact. He's also a trier of law. We presume judges know the law, so it'd be kind of to intentionally misquote a case would be not thinking the judge would probably know the case as well as I do. Would not be the smartest thing to do, but in any event, he had knowledge of the facts. He had knowledge of the law. He could disregard in that situation as sitting as both a trier of fact and law. He can disregard what he wants or consider what he wants. There's nothing in the record that indicates that the statements by counsel in any way resulted in his decision.
I think you're missing my point. There's nothing in the record that indicates that Judge McCarville had Mr. Wilson's version of what actually happened.
Besides the fact that counsel just told him, made comments about his lack of maturity.
Well, I understand, but there was nothing about digital rape or nothing about rape.
No. Just that there had been sexual conduct
Which-
with a 13-year-old girl.
And he pled guilty to solicitation.
Right, which is
Yeah.
less than sexual contact with a 13-year-old girl.
Counsel, we've taken a lot of your time with our questions. Would you like 30 seconds to wrap up, or do you think you've made your points?
Again, the reason I petitioned the Supreme Court for review is the other option was to self-report to Mr. Hazlitt, who was sitting here, on the issue of whether I had intentionally misled a judge. And I felt strongly enough about that. I want you to review that and see whether that's what the record shows or whether what Justice Boozer found in the dissenting opinion is more accurate. It was prosecutorial error, and we don't think that it caused any prejudice to the defendant in this case.
All right, thank you, counsel.
May it please the court, Caroline Zuschek of the Kansas Appellate Defender Office here on behalf of Mr. Grant Wilson. I guess to start, I'd just like to point out that it's basically irrelevant to my client and to our position whether this court follows the Sherman analysis or the prior McReynolds analysis in terms of was this ill will, was this intentional. For Mr. Wilson's purposes, what matters is, was it misleading to the court and was he prejudiced by it? And we believe that he was.
Let me tell you there are two things that bug me about your side of the case.
Okay.
I think we took one off the table, by the way, but the one that I think is on the table. if you had not alleged prosecutorial error or misconduct, however we go there, you would have appealed and you did, appealed Judge McCarville's ruling that there was no constitutional violation in imposing lifetime post-release
Correct.
supervision. Okay. So on review, that is a bifurcated standard, right? We look at the facts that the judge found and whether they're supported by substantial competent evidence, and then we take that and we apply a de novo standard, and that's what's bugging me about whether you're hurt by any of this.
Okay.
Because all you have to do is come up here and say, to the extent that he relied on digital rape, there's no facts to support that, and that's a slam dunk for you. I mean,
Right.
it's not in the record. So there's no substantial competent evidence. The defendant did admit to having sexual intercourse with a 13-year-old girl, so that's statutory rape.
Correct.
So that's on their side of the deal.
Yes.
And I'm not sure how to play this Proctor misrepresentation, quite honestly, because I think we have to assume that judges know the cases that are being applied or not. But let's set that aside. Why do you need to go the prosecutorial error path when it seems to me like you've got all the arguments you need to make to do what you want to do, which is challenge the imposition of the lifetime post-release? Does that make sense?
Yeah, and that's why the brief raised both issues, and actually why it raised this issue second. The Court of Appeals decided that the district court had not had the proper facts in front of it to make adequate Freeman findings under the first factor in particular, because it wasn't clear that the judge was properly informed as to the facts of this case or the facts of Proctor. And one thing that's been missing from this discussion is that there were 7 years between when this case was filed and when this motion was heard. So even if at some point the judge, Mr. McCarville, or just Judge McCarville had been familiar with the facts of this case, 7 years had passed.
Well, now, I don't think that's a fair argument, because your client was up in front of this judge several times through
7
probation
years ago.
revocations and that
Right,
sort
but
of thing.
he then was sent to serve, I believe, about a 7-year sentence. So the other references in this case are from 2008, and this hearing, I believe, was in 2015. So I'm not intentionally trying to, yes, he was there multiple times, but that was all significantly in the past. So I think that even if there are certain circumstances where the judge might be more familiar with the facts of a case, for example, if he just heard the prelim and this was at the original sentencing hearing, that's not what we have here. There was a vast amount of time in between those things.
Let me tell you the second thing that's bugging me.
Okay.
And I think the state took that off the table when they said they're not chasing the preservation issue, but it still bothers me. This is a non-jury hearing, and I practiced law for 29 years before I got this gig, and when we were in non-jury hearings arguing about cases and facts, everybody jumped in and talked about how the other guy is misstating X, Y, and Z, and here's why this is going on, and as I read that transcript, I thought Mr. Wilson's public defender very clearly understood the facts of the case and clearly argued Proctor, just like the state argued. That's why the state talked about Proctor, was because counsel did that. And so, at least in my experience, if the other side is claiming digital rape, which isn't true, and misstates a case, I don't know how, I think every hearing I ever had, non-jury hearing I ever had in my life, I think the other side misstated the case. Why isn't there some obligation here for the defense counsel to raise their hand? And it's not in this, it doesn't happen in this transcript.
No, it doesn't. And perhaps that's because the standard of review he believed applied was that he didn't need to object for the error to be preserved.
Well,
Perhaps he wasn't
Counselor-
paying attention.
Counselor, this let's be clear about how this came about.
Okay.
We have the state's motion. Mr. Stanton started arguing that. Then defense counsel answered that. Then the judge started announcing his decision and then inquired of Mr. Schrader as to whether there had been any drinking. And so that's when Mr. Schrader, instead of answering the drinking, brought up the digital rape and then said that Proctor involved a police officer impersonating him. So this came out. So was there an opportunity for the defense, since we're in the middle of the judge's ruling, to address that?
Yeah, and certainly we would argue there was no opportunity given to the defense to respond to the misrepresentations. The judge had already started its recitation of its findings. There was a specific question directed at the state. The state sort of got off track. I don't think it was ever answered whether he was drinking. So it's unclear whether the defense attorney even knew that he could object in that situation. Whether he should have done so anyways or whether I would have done so is sort of a different question. But the standard of review that applied was, of course, that in King, which is that there isn't an objection contemporaneously required for a non-evidentiary question.
But those are jury trial kind of questions, and aren't
Agreed, but the state didn't argue that some other standard should apply.
I don't want to. I guess I'm struggling with whether in the analysis,
Okay.
which would be step 2 of Sherman. Let's just assume Sherman applies for this
Okay.
question. For step 2, why wouldn't it be relevant in the calculus that counsel didn't object or speak up? And you can look at different facts and scenarios about, I'll grant you Judge McCarville didn't say, defense, do you have anything more to say? I'll give you that. But just in applying the test, should the failure of defense counsel to say anything or to do anything later, to file a motion for reconsideration, should that play any part of the analysis?
No, because the second factor looks at whether the defendant was prejudiced. And if the burden is on the state to show that there's no reasonable possibility that the error contributed to the verdict. So I don't think that there's a burden on the defense at that point. I think
it's an impact question.
I think in
is this
an ideal world, the defendant should object. I think that in the future, if this case comes out and says that, then defense attorneys will know their obligation to do so. But I don't know that should be the be-all, end-all. First of all, there's so many appellate cases out there, published and unpublished, of course. I don't think we can presume that any one person knows all of them. And that's why it was damaging to misstate the facts of Proctor here. I agree with you that it does appear that the defense counsel did know the facts of Proctor, but I think at the juncture at which this particular incident occurred, he didn't feel like he could object, perhaps.
He could have filed a motion for reconsideration saying the prosecutor committed error in the argument, and I didn't get a chance to speak up.
He could have, but the prosecutor has an independent duty of candor to the court, and that should probably have governed as well.
So we have a case here where we've learned today the prosecutor has conceded, stating facts that were not in the record, and also misstated Proctor. And it's your position that even given that, the defense counsel who was sitting there listening to all this had no obligation to stand up and say, Judge, before you continue, I want to be heard because of these two issues?
Did he have an ethical obligation, or does it change the outcome of the case? I think he should have objected, but I don't think that changes the result in this instance.
So when you say should have, do you mean an obligation to stand up and be heard on that?
I'm not sure, honestly. Obviously, I think it would be best practice to object.
I think that's true, but I'm trying
But I
to
mean,
find
that's
a
also true in closing arguments when a prosecutor misstates facts or misstates the law. and yet we don't require an objection there. And I'm not sure I understand the difference and why one should be required here.
And as a practical matter, it's never a real good idea when the judge is reciting his ruling and his reasons to appear to argue with that judge.
Exactly, and particularly in this case where Mr. Wilson was asking for something less than the statutorily mandated sentence. He was asking the judge for leniency, and I can see why the attorney wouldn't wanted to appear overly aggressive or attacking the state. He would have wanted to create a different sort of atmosphere to potentially benefit his client. And obviously the same goes in jury trials. You don't want to prejudice the jury by overly objecting. Nonetheless, I think that, yeah, the situation in this case made objection here specifically problematic.
On another matter, if we were to decide that the errors were harmless, do we remand to the Court of Appeals? They dodged the constitutional question that you raised on the constitutional avoidance doctrine. So is that what you would be asking us to do, is to remand it to the Court of Appeals to address the issue that they dodged?
Yes, Your Honor.
Do you have any further presentation for us?
No, I'm prepared to talk about what other states have done with the standard of review if you have any questions on that. Otherwise, I'll just conclude my presentation and ask that you affirm the Court of Appeals decision remanding Mr. Wilson's case back for another hearing on the Proctor and Freeman factors.
Just so I'm clear, it sounded from your comments earlier that you thought that our prior case law could apply to this situation in terms of what we expect from prosecutors and what happens when there is an error. And by that I mean whether this happened in a hearing like this without a jury, whether it happened during voir dire of a jury, whatever, you believe that there's no obligation to have objected? Is that a fair statement?
Again, I think it would be best practices to object. I'm not sure. And maybe that's even a factor the court could consider. I don't think it should be determinative. Mm-hmm. But yes, I agree that Sherman should apply.
That was my next question. Our Sherman test would apply for whether this is harmless error. Is that right?
Yes, that's what we would be requesting. If you look at the cases that were mentioned by the state and Judge Boozer, Wyoming applies a plain error test, but that's not specific to prosecutorial error in a non-jury context. That's the test they apply for unobjected to misconduct. So it's not actually referring to the specific situation that the court asked the question about today. In Connecticut, they apply an evidentiary test. Did the evidence have some indicia of reliability, and was it recorded? And again, that wouldn't apply to misstatements of the law. That would apply only if the prosecutor was bringing in evidence outside of the record. And to be clear, there are other courts that apply a very similar test to our Sherman test. For example, the Hawaii Supreme Court applies a beyond a reasonable doubt standard. And is there a reasonable probability that the error affected the outcome is the test that they look at, even in a non-jury context. And I think it's safe to say that there is a presumption that the district court knows and follows the law, but I think that presumption is stronger in cases where, for example, there's like a Fifth Amendment comment on privilege and invoking the right to silence. The court obviously knows the Fifth Amendment and those parameters. Here, where it's the facts of an appellate case that was fairly recent, I'm not sure that we can say that the court wouldn't be misled when they have a right to trust the prosecutor.
All right. Thank you, counsel.
Thank you so much.
I thank both of you for your arguments this morning. The court will take this matter under advisement.